Okay, this is Julio Zamora. Today is Friday, August 31st, 2012. Beginning this recording, bumping off the other recording, I left out the fact that I work 14 hours a day, 60 hours a week, and that I'm on call here since December 7, 2010. And there's 200 people underneath me in seniority. It's a 24-hour operation. I should note that I should get paid the 14 hours a day, 60 hours a week. Anything over 8 hours should be a time and a half because the hostler gets paid time and a half when he's working by the hour. He gets all the perks. OTR drivers don't get any perks or any overtime unless they're on the clock by the hour. We never see 8 hours anyway. But since I've been sent home because he falsified my documents and et cetera, I should get the same thing the hostler should because I'm on call, standing by 24 hours a day, and they're working people underneath me in seniority before me. So I should get the 14 hours a day or 7 days a week, whatever's right, as long as I get the time and a half after 8 hours. And that's how it goes. So here we go. Let's see what happens. Good morning. Today is Friday, August 31st, 2012. I'm making a fresh recording here on what happened on December 7th, 2010. On December 5th, I came in at 12:28 in the morning on 12/6/2010. My logs were perfect. On 12/7/2010, I came in and I was interrogated for 12/6/2010. The dispatcher or the company altered my logs from 12:28 when I arrived to 12:41, and my starting time, he changed that from 10:30 to 11:15 without my permission. He interrogated me on those issues on December 7, 2010 without a shop steward present or any listening device whatsoever. And they knew I had a severe profound hearing impairment since 2008, 9, and 10. He interrogated me, and then when he was finished, he told me to sit down. The shop steward's on his way. I went in to see Mike Sadler. He asked for my seniority. He showed me, I guess, some paper, if I'm correct, about September 18, 2009. And he asked for my seniority, if I would give up my seniority, and I said no. Shop steward said it was a safety issue. I told Mike Sadler, I don't know what you're talking about. I said, as well as the dispatcher who interrogated me, I don't know what you're talking about. He didn't show me anything on the bulletin board for September 18, 2009, and I don't recall anything. If I seen it, I don't remember, I don't know. You know, he didn't take me out to the bulletin board and show me exactly what he was talking about. He didn't point it out. So in the meeting there, he did what he had to do. Shop steward said safety issue. Then he said he's going to look into it. And then he sent me home. I asked the shop steward to clock out, and he said no. I asked him twice. He said no. Well, that was fine. He didn't give me anything in writing or let me know why he's sending me home or if I'm being disciplined or what's going on. Nothing. Just that when I left Mike Sadler's the safety manager, he said, I'm going to look into it. According to the contract, work first, grieve later. As Safeway Incorporated well knows that I had an offer of work because they agreed to it on 10/13/2010, and then I guess they held it up for a couple of months till I received a notice of the offer of work guaranteed for 1 year on December 1st, 2010. I also had an FMLA that was ongoing on December 1st, 2010. Okay, on December 3rd, 2010, I went to work. On December 7th, 2010, they sent me home on duty or on call or whatever. Because of the fact I'm saying this is because he said he was going to look into it. Look into it. He didn't say what. He said he's going to look into it. He showed me the letter for September 18th, and I was totally confused. I don't know what he's talking about. I'm going to look into what. So he sent me home, didn't allow me to clock out. I'm on standby since December 7th, 21, sitting here at home. Now the union received, I've sat at home here on December 16th, I called Safeway. No, I called the union local 439, Mr. Nicewanger, on the 16th. I had the speakerphone on. I wanted an update on what's going on with my status because I haven't been working. So he said, I don't know, I haven't heard anything yet. Okay, that's fine. After that, I don't know how long I waited, or I keep saying I got a letter or notified on the 21st or 22nd, but I'm not sure anymore. This thing is just, I've been sitting here for so long. And today is the 31st of August, 2012, and I'm still sitting here and haven't been paid or called to work. And I was hired in 2002. I have 10 years in August of 2012. I've got at least 200 employees underneath me in seniority. I should work first before anybody works before me. It's a 24-hour operation. So there's no excuse for them not working me, period, according to the contract. Now, at some point or another, I had Mr. Nicewanger receive two documents. Mr. Nicewanger received two documents. He received agreements filed by Mike Sadler on December 17th. On the Safeway letterhead, it says, and stamped, received, local 439. Received, it says, received December 17, 2010, local 439. The agreement that was filed. Now, that's not within 10 days. Okay, it has to be sent within 10 days as well as 2 registered mail. In fact, I don't believe that a Teamster can be fired at home due to the fact the contract says work first, grieve later. And then it also, if you get fired, they have to send you a letter of discharge and 2 registered mail with the grievance being filed. Or I have it the other way around. In any event, it wasn't within 10 days. Now, if it's not within 10 days, it's supposed to put you back to work with all back pay and benefits. That's been going that way for the last 10 years for 400 truck drivers, almost 1,500 employees there. If it's not within 10 days, they're put back to work. The shop steward takes the letter and gives it back to them. They put them back to work and they just pay them. That's how it is. That's how it goes. Because they didn't meet step 1 and step 2 of the contract. If it's not within 10 days, it's null and void, final and binding. Null and void, final and binding. Final and binding, okay? You're put back to work with back pay. That's what they do for 400 other truck drivers and almost 1,500 Teamster employees at Safeway in Tracy, California Distribution Center. Okay, that being said, so anyway, he received that on December 17th. Now, I didn't receive any mail, or I don't know if I received anything. I don't even recall receiving any registered mail. Okay, now he didn't respond within 10 days. He was told to respond by December 25th and approve his accusations. But he was supposed to put me back to work. Why I went further, I don't know. But that's what the letter said when he replied within 10 days, Mr. Nicewanger. And in fact, it was a fax and an email. And on the agreements that they filed down below on the left-hand side, who they sent a copy of that letter to, it says employee. It doesn't even have my name on there. Who they sent that grievance to. It doesn't have my name. So, in fact, they never sent it. That's what I'm going by. So now, we know they never sent me registered mail because of the way they filed the grievance, and it wasn't within 11 days. Now, like I said before, they were supposed to reply on December 25th, 2010 with all logs, with all photos, statements, whatever, to prove their accusations by December 25th. They didn't do so, and they were supposed to set a date and time for a panel hearing, okay, and I was supposed to go to a board of adjustments if it's suspension or discharge within 30 days. That didn't happen. They bypassed the board of adjustments. Why this hearing is going on, I don't know. Because, like I said, they were supposed to put me back to work, and they didn't do so. Mike Sadler or James Williams did not put me back to work. It's their responsibility. They know how it is, how it's supposed to be, and they've been doing that way as long as they've been working there. So I don't know why they didn't put me back to work. Okay, we know they didn't prove anything on December 25th, 2010. They didn't produce one solitary bit of evidence, nothing, because they can't. Because the time clock in the driver's room is not connected to the clock in the tractor. Okay, it's not connected. It doesn't change duty status. It doesn't do anything. It doesn't record what you do from the driver's room to the tractor. In fact, you should get paid because you're on a time clock because they have you punching on a time clock. I'm correct about this. I mean, you don't, your logs don't start until you get in the tractor and you have a 25-minute pre-trip. Okay, when you get into that tractor, and it's never at 10:30, automatic start at 10:30 every day, no matter what. Okay, so you got 25-minute pre-trip. As soon as you open that door to that tractor, you're on your pre-trip. Okay, so getting back to the time clock in the driver's room. Now, they have you clock in. You have to do two things at once. Well, actually, you already automatic start at 10:30. You're waiting for dispatch according to seniority. But when you get there, you have to wait in line according to seniority to clock in at 10:30 on the company time clock. We have a no-fault attendance policy, verbal warning if you're late. Now, I'm not ignoring September 18th that he posted, but it's like I said, we have to do two things at once. I'll explain myself. For one thing, we're under the Department of Transportation. You could say for 24 hours a day until our day off. We work 14 on and 10 off under the Department of Transportation, up to 60 hours, and then we have 36 hours off. Okay, let's make that clear. We're under the Department of Transportation 24 hours a day for 5 days until we reach 60 hours, and then we get 36 hours off. When we arrive to work, we're on duty, we're under the Department of Transportation. Will we have to clock in on a company time clock because we're instructed to do so? When we should log out of that tractor, we're not supposed to be detained from going home. So that we make our automatic start at 10:30 in the morning. That's the reason for that, and that's Department of Transportation. But we have a company time clock. We're required to clock out when we leave at the company time clock, and we're required to do that. We're also required to log out of the truck when we run out of hours wherever we are. Wherever we are, Livermore, Dublin, Eureka, doesn't matter. We're instructed to log out and drive the pickup truck back to Tracy and log out of the company time clock. Now the miles are not being recorded, and we're in violation, but it's not recorded on the logs. On the left-hand side of the sheet, there might be a time there when you actually clocked out of the company time clock. There might be. I never see it, but I seen it on this log. Why it's there, I don't know, but because it's not part of the log. It's part of the company time clock. As far as I'm concerned, that's falsification because I didn't say it was okay. Nobody's supposed to add, write, or do anything to that logs without my permission. Change my starting time, write anything on those logs. Those logs are mine. Nobody's allowed to alter it, change it, or write anything on there unless it's a log correction. And then I have to sign it that it's true and correct. Now, they go around and putting that time down there from the company time clock, they're in violation. I didn't give them permission to do that. And it's on that log sheet. It's also got to change the time from 10:30 to 11:15 from the company time clock. Now the tractor has a data machine in there that picks out a log and an algorithm sheet that tells the DOT and the company what you're doing minute by minute. Okay? Now they must have an agreement with the Department of Transportation regarding the 25-minute free trip. Because of the fact that they're starting the 10:30 start time, when you arrive at work, your clock is ticking in your truck. And you're not in your truck, you're waiting to be dispatched or your trip sheet at 10:30 according to seniority. So when you arrive to your tractor, you're not there at 10:30. You're 5 or 10 minutes late, or you're in your room preparing your route. Whatever the case may be, it doesn't matter. You could be in the office getting disciplined. It doesn't matter. You still... clock will start at 10:30 in that tractor. Now, that's the way they have it arranged. I've been driving the truck for 50 years. That logs don't start until the tractor gets into that, the driver gets into that tractor and starts them logs himself. And your time starts when you log in, when you get to that tractor and not before. No, they have company policy, and that's the way they do it. Fine, let's follow it. I do it, and I don't have no complaints about anything they do. I'll just follow it. Now I got two policies to follow: DOT regulation and company policy. Okay, that's fine. I don't have a problem with that. I'm not complaining. I'm thankful for the job. But to be escorted out to property and say that I was intent to falsify logs when the dispatcher falsifies my logs, and then it makes a false accusation, there's no doubt about it, and then I'm sent home because they're looking into it and violate the contract, and I'm sitting here since December 7, 2010, not getting paid, and they don't even show me clocked in, and I clocked in on December 7, 2010, and this guy, dispatcher, whatever, says that I punched in late. Well, for Christ's sakes, man, if I punched in on December 7th and don't show me there, it's not going to show me being late on December 6th or December 5th, whatever. Okay, because he's talking about December 6th. Okay, so I punched in at 11:15. I don't know. I don't really remember. I just agree with everything he said. Because I'm not going to commit insubordination against him, Mike Sadler, the transportation manager, the safety manager, or James Williams, the transportation manager. I'm not going to commit insubordination. I'm not going to talk back to them. No way. They want to say all they want to say and accuse me of this and that. That's fine. Go ahead. As long as there's no shop steward present there, I'm not going to reply. And if there's not a listening device because I have a severe profound hearing impairment since 2008, never received medical attention or hearing test, that's not my fault. I have a right to have a listening device, and I have a right to have a shop steward present. They denied me all my rights. And the contract, they didn't follow it from A to Z. They violated Article 25, 26, 28, and all articles of the contract of Teamsters Local 439, a bargain agreement. And they also failed. They made an agreement with Workmen's Comp to work me for 1 year. And they agreed to that on 10/13/2010. They didn't honor that, and they didn't honor the FMLA. They took me off work illegally. And they stripped me of all my medical benefits and everything else. And you know what? They're not allowed to do that. Not if I'm an FMLA. They're not supposed to take my medical benefits away. Okay? And they violated that offer of work, which is a violation of 132A. And also a violation of 132A for that FMLA, if I'm correct. So they violated it twice. And they didn't put me back to work. And Mike Sadler, safety manager, and James Williams, transportation manager, know about this, and they should return me to work because Mike Sadler, the safety manager, did not file the grievance within 10 days. Now, they do it for 400 other truck drivers and 1,500 Teamsters, almost 1,500 Teamsters at Safeway and Tracy Distribution Center in Tracy, California. If it's not within 10 days, they put them back to work. They put them back to work. And I'm sitting here since December 7, 2010, and they did not put me back to work. And I asked for arbitration. I was denied. I was denied arbitration. I suppose they could do that. And my understanding, if they can't afford it or it's too expensive or they don't think they can win, they can do that. But if they do that, they're supposed to assign me an attorney. I have a right to be represented by an attorney, and the union's supposed to get me one. They didn't do it. They just said I couldn't win the case. I'm not going to take it. We're not going to pursue it. But you can pursue it under workman's comp. Well, that's just great. They deny me arbitration, and they deny me a right to an attorney. But they're supposed to pay for it, and then I never received it. In fact, I never received anything. And if I stand to be corrected, if they did send me a letter or something, I would like to see it because I never seen one. So we'll go back to December 25th. They set a date and time for January 11, 2011. That's 14 days from December 25th, 2010. That's another 10-day violation. Okay, and I don't even know why they went that far. And then they didn't even let me, didn't have a listening device at the hearing. I didn't hear, I didn't understand what they were going to say. And my life was on the line. Why would I say anything unless I have a listening device? And then the union says, oh, yeah, well, if you're supposed to have one, well, we'll look into it, we'll get it. Mr. Nicelonger said that. That's my understanding, that he's going to make sure I get one in front of the two shop stewards. And then I told the shop steward, if you're an authority on hearing impairment, fine. But he stood there with his mouth shut in a state of shock. So, and then they sent us home, and they went into caucus without me being there, and I was never notified of what was taking place. Not. They don't have to, but they could at least send me a letter whether I was fired or not, because the discharge was denied on December 17, 2010, because it wasn't within 10 days. So why they did all this, I don't know. But they need to put me back to work. They violated everything possible. And even workman's comp is a sham. It's terrible. They're not enforcing the offer of work. They're not enforcing the offer of work. And Judge Grill takes it off calendar. Why is he taking it off calendar? I presented him the medical certificate for severe profound hearing impairment because the attorney didn't introduce it. In fact, it's my understanding, he didn't have any documents on the table. And he was kind of like surprised when I handed him the documents and other documents that I have. But he only took the severe profound hearing impairment, and then there was a debate going on between my attorney and my witness as far as presenting documents. All of a sudden, there's no evidence. Now, I don't know what that's about, but he took the case off calendar. So now I'm still sitting here from December 7, 2010, when I should be working. I look at it as a retaliation. I don't know how other way you can look at it. So that's what I got to say about that. James Williams, the transportation manager, is responsible for putting me back to work. Mike Saller, the safety manager, did not respond within 10 days. He's got the responsibility to put me back to work. He didn't do so. So that's where I'm going to leave it, and I'll play this tape for whatever. But this tape will be played at some time or another.
Good morning, this is Julio Zamora at 1385 El Camino Way in Los Banos, California, 209-829-1787. I work for Safeway in Tracy, California. I'm an OTR truck driver. I was hired in August of 2002. I'll have 10 years in August of 2012. I'm bringing a statement here regarding the Department of Transportation regulation, and if the company testifies as well and makes a statement what is and what isn't under the DOT regulation, I request that shouldn't be allowed any testimony regarding the Department of Transportation regulation that should be introduced. They need a director from DOT or an employee from DOT My life is on the line, so I'm asking the judge to consider it. Okay, due to the fact that I'm being held hostage here in 1385 El Camino Way for false accusations of falsification. Because the question needs to be asked. You know, I filed with a total of 132A's for every action that they did towards me. I filed harassment. And the third one was, the fifth one was hearing impairment. The union took the position and agreed with the company on almost 100% of its testimony or whatever it is, and the documentation. I don't know about that. They keep citing the CBA rules, this and that, and yet they don't follow it. What I mean by they don't follow it is that they didn't respond in 10 days like this was supposed to, and there's 1,500 employees at Safeway under the Teamster contract. If it's a step two, if it's not certified mail or whatever within 10 days, it's null and void, final and binding. Null and void, final and binding. That's step two. It has to be completed. Okay, they didn't do that. Okay, and they also didn't respond within 10 days by December 25th, 2010. Okay, so that's why I made that statement. The union supports it, and I don't understand that. You know, I didn't do anything wrong. You know, they fired me for falsification. Falsification, the machine is tamper-proof. I should like to note that the machine is tamper-proof. Worse than that, I've been there hired in August 2002. It'll be 10 years in August 2012. And you know what? I got attracted there with a machine that's tamper-proof, like I said before. And not only that, I've been there 10 years or going on 10 years, and I've never seen a log. I've never seen one log. Once in a while, they'll give us the logs for the last 5 days, but that's not very often. Okay? So when you go in the morning and you punch it on your computer, which is automated, whether you log in or not, you're on duty automatically for 14 hours. No matter what, it's automatic. You're on duty 10 times, boom, boom, boom. It's automated. Okay? He punches in the route, boom, boom. It's automated. Okay? My point being is I never seen a log. I come in for work at the end of the day, I don't see the log. The only time you would ever see a log if there's a log correction. And then, you know, sometimes he just says sign it and that's it. Which he does to me sometimes, like he did once when I couldn't drive anymore. Okay, and he said, well, you could have made it in, right? Well, he's right, I could have made it in if I didn't stop the rest. And I just signed it. I didn't even look at it because it was ridiculous, okay? I don't want to get in a debate with him because I don't want to commit insubordination, so I'm going to keep my mouth shut, just like I did with the dispatcher. Disagreed with everything he had to say. He could say anything he wanted. He didn't accommodate me with a listening device or a shop steward, period, according to the contract. And he knew it was going to be a disciplinary matter, so there was not a matter of asking for a shop steward, which I probably did at the end of August Raven and whatever he was doing, you know, because he was all about December 6, 2010, so he knew what he was going to do before he did it. There was no doubt about it, okay? And the fact is, I've never seen the logs. I've never seen them. I don't know how I can falsify or alter a log or anything else if I've never seen a log for 10 years. And the fact is, I've never seen a log for 10 years. I hate to repeat myself, but the fact is, on December 6th, which he's accused me of falsifying the logs, there's never been a log correction other than I know of in 10 years except for one, and that's when I was tired and I pulled over. So if I'm guilty of anything, you have to sign the log correction to establish the fact that you violated DOT regulation, which I never done anything, no such thing on December 6, 2010 to establish the fact that I falsified anything. And that's the Department of Regulation. They are not to alter or touch those laws without my permission. It's against the law. Now, I have a machine. A machine doesn't have feet or arms. I'm pertaining to the time clock in the driver's room, which has nothing to do with the computer So the logs cannot be touched by the driver. He couldn't figure that one out. And I couldn't figure it out. And then I happened to mention that we have a time clock in the driver's room. Okay? And he asked me, why do you have a time clock in the driver's room? I don't know why. They want us to punch in. He said, but you're already on duty when you punch in, and you're under the Department of Transportation for 14 hours. And furthermore, and before they test your logs, which they're not supposed to, it's against the law unless they have your permission. That's against the law. Okay? That's falsification. So I left it there. Me and my wife, he said he doesn't want to get involved. The person that said he didn't want to get involved was, we went to the Highway Patrol Office, to the Department of Transportation, and had him look at all the documents. Remains that I didn't alter the log, and he made the statement, and I have a witness, and so that's where it lies. I don't know what to say. I just gotta make a point of the fact that I never see the logs. And the clock in the driver room has nothing to do with the computer in the tractor. Okay? The tractor is automated. Okay? The tractor prints out logs in the master computer. The time clock doesn't print out logs in the master computer. I need to change my logs from 10:30 to 11:15. The computer in the driver room does not have any authority, even though it's a machine, to change the logs in my tractor when it starts at 10:30. Okay? A computer doesn't talk like a human being. I don't know how they get their wires crossed, okay? But the fact is, I was there on time. And yeah, I had a senior moment to correct about that. But to attempt to falsify logs, they need to be corrected. They need to be corrected. Okay? Because of the fact that we have a no-fault attendance policy. It's company policy. It's there. I got rolled up in December 2009 or January 2009. And I got rolled up, and I was on disability, and I got 12 points. And I got a copy of the document. But we don't need to go there, do we? Absolutely not, because Mr. James Williams was supposed to put me back to work when they didn't meet the 10 days like they were supposed to under the contract, null and void, final and binding. And they did that for the 300 other truck drivers or 1,500 employees there, whatever. If it's not within 10 days, they put them back to work and give them the back pay. Now, James Williams knows this, and he should put me back to work and stop holding me hostage here in Los Banos at 1385 El Camino Way, and sitting there on duty waiting for a letter or something to be returned to work and go pick up my hearing aid in Turlock, which they have the name and the number of where I'm supposed to go. And it's not a hearing aid that it's a volume control up and down. No, it's a special hearing frequency hearing aid, because I don't understand words, letters, and background noise interferes with that. So, that being said, it's a special hearing aid. It's not one that you can buy for $29.95. Okay, now I already bought my first set, and I spent a lot of money, and it wasn't the right one. And I got a prescription, and she knows how to fill it out. So, and the doctor is the one that did the examination and then sent me to her. Okay, and she says, yeah, I can order this. This has to be specially done, and it's not going to be done in one day, okay? It cannot be done in one day. So it's not a volume control type hearing aid. But I'm sure Mr. Williams knows this, right? He's a terminal manager. They're responsible to know all these things, so I'm sure he knows about it. So that's all I'm going to say on that he needs to return me to work. And I think they did all this because of the workman's comp that wasn't going to get out from underneath it, even though there's problems with workman's comp also. So I won't go into that. This is a union matter, and I'll leave it there. I'm not accusing or saying anything about what they should do, what they shouldn't do. I'm just presenting the facts. And I'm asking that I don't have to pay attorney's fees because of their behavior. It's discriminatory. There's no doubt about it. It's absolute. And nobody has spoken to me for 3 years. That's why I'm speaking the way I am now. And then again, I'm not sure if I know I'm rattling on, but after all, I'm fighting for my life here. What do you mean your life? Like you're gonna die or something? No. No. What I mean by my life is that they accused me of falsification of documents, okay? And I need to be returned to my job so that I can be cleared of all wrongdoing. Be cleared of all wrongdoing so that I can obtain employment. That's why I'm held here hostage. I can't get a job because of the false accusations about me changing the starting time to 10:30 to 11:15 on a document that I never see or have seen in 10 years since I've been there. When I come in off a route, I don't see any logs. So I'm being held hostage here, okay? And I can't get employment. I can't obtain employment. They got me hostage here. I must return and be cleared of all wrongdoing by them making a law correction in the remark section according to Department of Transportation regulation. And that's the only way it can be fixed. It's got to have a law correction. So there's no record of it. Okay, so I can't obtain employment until that's done. Now James Williams knows all this. So this must be all intentional because I've been off work for so long. And this is July 2012. Imagine that, since December 7th, 2010 to July 2012. And I'm sitting here as a hostage and unable to obtain employment because of the way they sent me home on December 7th for the accusations on December 6, 2010. I can't obtain employment. I gotta be returned to work. And James Williams knows this. And so why he's doing this, I don't know. So somebody needs to find out why. You know, I mean, Myla Sadler violated the 10-day rule. Within 10 days, they violated it 3 times. So there's no excuse for their behavior. So I'm going to say it's discriminatory, et cetera, and leave it there. 100 miles to work. And I've already been off work 2 to 6 months. I drove there to work, right? And he said, oh, you can't work on your day off. I think it's kind of peculiar that I should be treated indifferent. But as they say, they got to take the lumps with the bumps, right? So I just move around, and here I am with nothing. My life is on the line. So it's up to the judge to decide what's the proper recourse, but I need to be returned right now. And as far as those other issues, that's for the judge to decide what to do, but I'm also asking for them to pay, same way to pay the attorney's fees according to the law, federal law, the Disability Act that was amended by the United States Congress of America. If they have a problem with that law, that amendment, like I said, if they have a problem with the Disability Act and that law and that amendment, then they need to take it to the Supreme Court. They can't take it to the Supreme Court. They got to take it to Congress to resolve their complaint. Because I have the same issue going on with the Teamster Union. And James Williams knows that he should return me to work, so I'm just thinking it's